Good afternoon. My name is Jeff Donfeld, and I'm the ASUCLA president. This afternoon, your student government and the speakers program is again making an attempt to present to the student body speakers who will present ideas across broad political, economic, and social spectrums. This afternoon, we have Mr. Melvin Belli. I'd like to give you just a brief background. Mr. Belli graduated from the University of California at Berkeley and received his A.B. degree in 1929. And then in 1933, he graduated from Boalt Law School at Berkeley. He specializes in trial law, both criminal and civil. He has been counsel in cases tried in England, Japan, Italy, and the Scandinavian countries. He has represented clients who have received the highest jury awards in 6 states, and in over 100 tort cases, his clients have received over $100,000. On December 3rd, the speakers program will be presenting Mr. Mark Lane, who will present another point of view on the Warren Commission report on the assassination of President Kennedy. I believe that his views differ slightly with Mr. Belli's. It is now my pleasure to present to you Mr. Melvin Belli.
Mr. Chairman, that was a delightful introduction. May it please you, ladies and gentlemen, with this delightful large audience of voters, if only I could have been here and spoken to you about some of the things maybe a couple of weeks ago. We could have changed the course of events, but I doubt it, because I think I would have voted for the same person that you did, or at least that I hope you did. But I'm not to talk about politics today. I'm to talk about law, and I think law encompasses politics, economics, and all of that money that you told about, that there must be somebody from Internal Revenue in the audience here, and he'll probably be at the office by the time I get there. No, I had a delightful experience the other day in Chicago. I went back to Hugh Hefner's establishment. He does that magazine called Playboy. You see that I'm not used to those sociological institutions. And I was taken into the, he said, would you like to see the bedroom? And I said, yes, I'd like to see the bedroom. So, salivating, I went into the, I'll get serious after a while, but that was an awful flight from San Francisco, and I'm trying to be able to stand up again straight here. So he said, you'll have to take off your shoes, which I did, and there was carpet with pile on it about a foot thick. And we went into the bedroom there, and we worked about 2 hours on his electric typewriter as he did the philosophy of sex. And as he did the philosophy of sex, through the open door you would see the bunnies flit by, and also the stewardesses go by. And he has 2 dormitories there, and of course the swimming pool downstairs, and this brass pole that you come into the garage and slide down to the basement. And we were going around through all of these rooms and doors, and next thing I knew, we went through the final door and we found ourselves out on the street. That is another lawyer and I, and we stood there looking up at the place, and both with the same accord said, what a selfish man. But I shouldn't tell you anything about that, because I understand they are to do an interview on me, one of those interviews that they have, and I was very flattered until I noticed reading Playboy for the first time, that is formally, that I saw that about the last one was done on Cassius Clay, so I follow him on in. And then after that, the following week, I went to the Virgin Islands and tried a case. No connection, of course, so I won't tell you about the case in the Virgin Islands. But I think I should tell you, in the very short time that we have, something, if I may, about trial law. I fancy that I am a trial lawyer, about as serious a profession and about as rewarding a profession as you could embark upon. And I hope that you may feel, just in these few minutes that I talk to you, something of the atmosphere, something of the aura of being a trial lawyer. I think it's a profession that has as much of service in it as the priesthood. You do have to love your fellow man to be a trial lawyer. If you want an easy job, you go out and be a ditch digger or a steel worker where you're through at 4 or 5 in the afternoon. You don't have to work on Sundays or weekends. As a trial lawyer, your every waking moment is being given to the gestation, the borning of a thought. In the middle of the night, or taking a shower or shaving, comes to you the thought that you may use on cross-examination. It's rewarding financially, it's rewarding in the service that you can do to your fellow man, and that's why I do resent when I've had the opportunities that I've had to address students last Saturday at the University of Montreal and the week before that at Yale and Harvard, that to me there attaches some sort of this stigma that I'm not dignified in court, that I don't appreciate the due process of law, that there's something of flamboyancy about me. It's true, but I did go down to Dallas with a red velvet carpet-bag briefcase that I've had for years, but I only paid $35 for it, and when I left Dallas, I noticed they were selling them in Neiman Marcus with another zero, $350, so I at least added to the economy down there. If I say no more to you, why is it that America contrives to look its very worst in these great cases, the cases of the Scottsboro case, where Leibowitz, the lawyer, went down to Alabama and said what a horrible justice there was. And you remember when he left Alabama with one foot on the rail of the Pullman car, he was sure that it was ready to take off. He said, this jury, they look like frogs sitting on a log. I saw their bloodshot eyes, their cruel tobacco-stained lips. He wasn't criticized by the American bar or anybody else for telling that truth about Alabama at that time. I remember in the Scottsboro, the Scopes case, when Darrow went down to Tennessee, and I remember in the Sacco Vanzetti, that's still being spoken of, a Supreme Court justice castigated. Was it Judge Thayer who said these men are guilty as hell? And then I remember just the other day, and in current history, even more current history than in the Ruby case, and you must read the Habeas Corpus Petition, and you don't have to be lawyers to read that. You don't have to be lawyers to read about our great and grand law. I think you can read it with knowledgeable mind and see the years and the antiquity that has come to us and the practicality that's come to us. Read the Sam Shepard case, where he, as an osteopath, was held guilty of murder. I don't think he'd ever been convicted had he been a doctor, and see what they did to him and what they did to his lawyer and what they did by means of the Cleveland Press and the habeas corpus. Now, due process of law after 10, 12 years. Due process of law, 10 years, 12 years too late. So I say, why is it in this country, this law of mine that I think is as grand as any profession you could achieve? If you want something dramatic, if you want something prosaic, if you want something staid, if you want something exhilarating, this has them all. It's difficult to do anything, to go into a drugstore. At least it is for me now as a trial lawyer, and I think in the sense that Shakespeare must have been a trial lawyer, he knew so much about everything, and not in a dilettante sort of a way or a perfunctory sort of a way, and a real depth, visceral sort of a way, because you can't put someone on the stand, you can't cross-examine them unless you know more about their subject than they do. And that's with epidemiologists, that's with chemists, that's with neurosurgeons, that's with a flight engineer, that's with a weatherman. To query him as to dew point at the airport or dew point downtown, is it not different? So you must know something about everything, and it's tedious, it's exhilarating, it's majestic. It's as boring as that man who's probably in the lay eye the most dramatic of all, the brain surgeon. Have you ever seen a brain surgeon work? Who sits at the head of the table, and they're tediously by the hour, by 2 hours, with double glasses on, meticulously picks out pieces of brain tissue under a local anesthesia while he tells the man to talk, to whisper, to say something, to count numbers, tediously so that he won't go too far, or that he knows what part of the brain tissue to cut. For every hour in court, there are some 25, 30, 40 hours outside of court, and that's which flows so easily by my good friend Raymond Burr and Perry Mason and the defenders, that seems to come out so gracefully for them. It never has for me. It's like the iceberg You see only one part of it in the courtroom. You don't see this work that's done in the library. I go to the library. I go to the library on Saturdays and Sundays and on holidays, and all good lawyers do. And that's why I say, if you want something that is majestic, is rewarding, is hard, is difficult, and is the practice, because you're never an accomplished or finished lawyer. You practice for the rest of your life after you leave a law school. So, just a bit then about my profession. And I hope that you do feel in those few words from me that I have a great appreciation for trial law. And I don't try causes. I try individual cases. I eschew the man who says, I try causes. I try civil rights cases. I try labor union cases. I try political causes. You don't. If you're a good lawyer, you try individuals. A doctor doesn't operate on a whole hospital. He doesn't operate on a whole ward. He operates on one individual. And then, if that individual comes out of the hospital with a tremendous new procedure, think of the first cardiac case. Think of the first time that they entered the cranium. Think of the first time they did a goiter, an appendectomy. You didn't operate on a whole hospital. You didn't operate on a whole ward. You operated on an individual, and he may come out of there with a sign on his back, I'm the first one that this procedure was ever done. Or you may try such a case as the Salk poliomyelitis case, and that may come out of the appellate court as ours did, Gott, Stanker, and Phipps, with my name as counsel, which established whole new law in California, or down in San Diego, trespass to personality, which is going upstairs into the appellate court now. Or the one that I'm going to try tomorrow in the appellate court, the Phillips case. Remember the chiropractor? Dr. Stratzman from your university testified in that case, and that was the one that was in Life magazine. But afterwards, if they're majestic, you've got to remember when they come into your office, the Dartmouth College case, or these great cases that you know and remember of the law. They don't come into your office with a sign on them saying, I'm Marbury and Madison, I'm the Scopes case. They have nothing on them except a humble human being who comes into your office, and it may be a man who came into my office, filthy, dirty. The girls called and said, you better see him soon because he's smelling up the reception room. And that was Charlie Simon, and in that case we tried and went all the way to the Supreme Court and established a landmark of plaintiff's personal injury law, and it came down now with the legend Simon against City and County of San Francisco, but we didn't recognize him when he came in as such. So I say again, eschew the man who says, or the man who is introduced, this man tries causes, this man tries unpopular cases. You don't. You try individuals. You operate on individuals, and that you must do whether you're a lawyer, a doctor, or a priest in the confessional. You hear the confessions of individuals, not in mass. And so it is something that you see of this majestic service that you have with this great law of ours that comes down from antiquity. And if only I could somewhere along the line talk to you in a seminar or informally and try to enthuse into you that which we're doing at Yale now in the final analysis, trying to get more of the advocates, more of the trial lawyers. Because I think the baton of leadership has passed from the trial lawyer as he was in the past. You remember the Mr. Tutt series, or maybe that's before your time, where you had the tall, gaunt figure with the stovepipe hat, the man who stood for the morals of the community, and if there were a bond drive or blood bank or anything, they would get the lawyer, the trial lawyer, and he would be the collector of the mores or the morality of the community, and he would lead, but no more. Now, apparently, as I say, the baton of leadership has passed to the banker, to the insurance man, and to the real estate man. We do need more trial lawyers, and we don't need more of the business lawyer. We don't need more of the tax lawyer. We need the man who has learned of human rights and the man who can stand up and give us leadership locally and internationally and in Congress. So much for the trial lawyer. And now let me tell you something about Dallas, which is just about the anniversary of that tragedy when we lost the man who would have been so great in this term and who would have been even greater after he left the presidency when he went up or was going up to Harvard and established a school for political science. And I think he would have done more there to have built our political lines along those of the civil servant in England than anything that could have been done. So if you thought it was a tragedy of what we lost at that time when his life was aborted on the Dallas public streets, think what he would and could have been even after he left the presidency. Now, Dallas. My publisher tells me that I'm a mendicant lawyer now. I must hold the book up to you and show it to you, and I know that you won't foreclose my right of publicity in announcing that I did this book because I got no fee in the case, and we're trying to pick up a few dollars by selling the book, but you can get it at your bookstore. But it is a good book. I can say that because I wrote it with the guiding pen of Mr. Carroll. Now, if I were doing, this modesty is really unbecoming a lawyer. I think that it's got to be in context. If I were doing a book review of someone else's book, I would have the temerity to say, without knowing all about that book and not having written it, whether it's a good or a bad book. This book I wrote, so I can tell you, knowing all about it and every word in there, it's a good book. So much from that, and we go along from there now. In the very short time that we do have, I hope that I have prefaced these few remarks. I hope you've got a lot of insurance here. This isn't very far back there when I start backing up on that. I've got to mention that subject of insurance sometime in my remarks because, every morning I'm supposed to sue insurance companies. I really have nothing against insurance companies. My economic function in life is to make insurance companies give out some of that money that they're holding in trust for us, the injured people. That's a collective us because the lawyer gets a fee on that too. But as a matter of fact, I genuflect toward the east every morning upon arising in the direction of Holy Grail Insurance Company, which is my bête noire, or the apocalypse of the State Farm Mutual Insurance Company, to mention their name. Now, a little bit about Dallas Justice and Jack Ruby. And in this context, I don't think I'd ever done this book if it was in complete destructive criticism. I guess you learn as you get a little bit older, and how old you so soon get. I was talking to some students the other day and telling them I'd left a book over at Bolt Hall about a week and a half ago that I was going back to get when I was still in law school. Just a week and a half ago, and I never did get that book. But that week and a half has stretched on out now to some 30 years of practice. I was out of Bolt Hall in 1933. As you get older, you do get a mellowing, not in spirit, not in the desire to fight for your client, but you do get a little more mellow in your courtroom demeanor, in learning not to criticize. And over the years, I think the image of flamboyancy that's been given to me by Life or the Saturday Evening Post is not a true image. When you look at the law books, I've never been reversed for misconduct or had new trials granted for misconduct. And again, in these procedures that we have developed a lot of them. In warranty law, and the Salk vaccine, and airplane law, and in the new tort of trespass to personality. I think we've developed those things out of a deep love and spirit of the common law, that we feel that the common law can give us guidance, can give us all the law we need without going to the legislature. What a majestic thing it is, how capable it is of growth. And I think, was it Holmes that said something about a thought not being an immutable thing, but it's like a skin that can expand and contract, and so is the law. I wish that I could tell you some of these things that you must, when you're undergraduates, regardless of what discipline, and the profession is a discipline, go into, what you must learn. If you were to come to me and tell me, or ask me the question, what shall I study pre-legal or what shall I do for the law, I would give you two answers. I would tell you that Dean Pound, who was the greatest living lawyer, who died, I think, probably 2 or 3 months ago, and was dean on the campus here of your great law school. We sat down, we tried to figure out a curriculum for lawyers and for pre-legal students. We figured out a beautiful one. It had everything in it. It had all the sciences and all the cultures. The only problem was it would take you 99 years in order to accomplish it. So knowing that life is short and you speed through it so fast, that you must choose. You must take some electives and you must eschew other ones. You get into law school, am I going to take labor law, or on the other hand, shall I take international law? What shall I take? I would say, if you did nothing else, take one subject. Take Chinese paper hanging in pre-legal, and take that Chinese paper hanging and exhaust the subject. Learn the modus operandi of studying, of exhausting, of sitting, of thinking, of speculating, of going beyond the horizon, getting everything that's in the book in this country, and then see if there's something that can be translated in a foreign language or in another country. And you get a modus operandi that stands you in such good stead when you get out into the law. The other day I tried a very famous case. Bill Capell, the great pianist, in an aeroplane, ran into Half Moon Bay and was killed. It was 10 years that we tried that case. And finally we went into New York. It happened in San Francisco Bay, or near San Francisco Bay, and we go to New York. We try it there under the Warsaw Convention, under not our law, but under a foreign law. And the judge comes, the complexity of this case, the judge comes, Judge Willis Ritter, a federal judge from Utah. And he sits in New York, and we try it. And we lose the case after about 9 years. And after we lost it, I sat in this modus operandi, and I thought we're in better position now than if we'd won it, and we moved not for a new trial, but we moved for judgment non obstante verdicto, notwithstanding the verdict. Judge, enter judgment now for the plaintiff, and then just send it back for the matter of damages. So this thing about Chinese paper hanging, and when you've exhausted everything that's in the book, then look elsewhere, look in China and get an interpretation. Well, what we did, we went to Harvard Law School, and we went and got the old books that they have on the Warsaw Convention, when they had the actual convention. We got the Lord who went from England, we got his remarks. Then we got what is willful misconduct, a concept that we have. Aggravated conduct, not negligence. You have to show willful misconduct in order to get beyond the $7,000 limits and then have an ultimate limit. We would have been limited to $7,000 had we won the case. We lost it. So I had to get beyond, I had to get the new trial or the judgment for us, and I had to get to the 7,000, and then I had to get beyond the 7,000. So we got all the translations of the original notes of the convention, and we found that the French have a different conception of willful misconduct, and there was a semantical barrier there, willful misconduct, faute lourde, and the Italians had a different concept, and we put that all together. Then we gave a concept that was never considered in this country before, and the judge gave us this judgment notwithstanding. We went back to New York and he tried it again, and instead of getting the $7,000, there was an award for the pianist of $900,000, just a little short of $1 million. And that came because of the modus operandi, the exhausting of one subject and just hewing on through it. And with the Cutter poliomyelitis vaccine, the little boy from down in this area, the little May boy, remember, we had years in that case. And in that case, we went to trial up in Oakland, California, and there on the witness stand in front of me was a Nobel Prize winner, Dr. Stanley, and all of this talk to the jury about, well, we don't know if the vaccine was killed with certainty, live and dead, and he was telling the jury this concept of life and death is something that there's no fine line. I deal with the living crystals. And you know, ladies and gentlemen, my living crystals, they live. They mutate. They almost have marriage ceremonies, nuptials. They have children. How can I say that they're not alive or that they are alive? And the same thing with the virus. And we had our Dickens' own time with that, but the modus operandi of exhausting. So we went right to the source. We heard that Dr. Stanley had testified before a congressional committee. We went out on the telephone, and I asked my partner, Lou Ash, who was sitting next to me, first go out and get me something to cross-examine this guy on. I saw him, that jury, you know, like at a tennis match here, and they were going along there. It took him the first 3 hours to give his qualifications from the University of Beirut, working on through Switzerland, Harvard, and back on out to California, which he reached about 2 minutes to 12, and thereby gave us the time to run him down. Well, my partner first came back, and my partner gave me a note. This man says that he'd won the Nobel Prize. He says that you cross-examined him, and that year they divided the Nobel Prize. He only won half of the Nobel Prize. Well, I could see myself pointing a finger at him and said, "Doctor, you lied. You only won half the Nobel Prize." So Instead of that, this exhaustion, the knowing of where the sources are, like you'd learn if you exhaust one subject, what library, what private library, what public library, where you can get these things. We sent someone out, and he phoned Chicago, then they phoned Washington, then we got the notes out and we exhausted them, and we found out that Dr. Stanley had testified before this hearing in Congress, and in the hearing he said, and we were defending, of course, Dr. Jonas Salk in this case, in essence, showing that the virus of the vaccine was bad. We were trying to show that Dr. Salk knew what he was talking about, and Stanley didn't. And we finally got these words that we read back to Dr. Stanley, which said when he was testifying, "All I know about is tobacco virus and crystals. I don't know anything about this poliomyelitis virus. I leave that all to my good friend and confrere here, Dr. Jonas Salk." Well, when we presented that with him, it just blew the case out of the water, and apparently had a great deal to do with the ultimate award. And then after that decision, coming on down here in the Superior Court here, and there being an award for some $675,000 for the little May boy. Now let me tell you one other personal rewarding experience. I do want to talk to you a little about Dallas and the time that we have here. You know, I've talked so much about, frankly, I have talked so much about Dallas and the Ruby trial that I guess there's really a mental barrier to get into it. I get pulled before TV and the radio, and every lawyer is reluctant, of course, to hear his name mentioned over TV or radio. You know, it's a funny thing. All of these fellows that say you shouldn't have publicity as a lawyer, and yet I've seen no head of any bar association suing a newspaper for coupling his name with the winning side of a lawsuit. I don't think that we ever will, but that's my battle with the American bar, which if we have a few minutes I'll tell you about a little later on. It's a delightful thing. Maybe I shouldn't put it in that form. A little more enthusiastic, perhaps. Well, one final thing, and in Dallas. And that's down in San Diego, and I can mention this case because it's in the appellate records. Anything that reaches the appellate records, of course, we can talk about. The thrill that it is in trying a case again and finding eventually that there is a legend on that case or a name to that case, and you have made law. When I was in law school, Justice Brandeis, writing in 4 Harvard Law Review, said there ought to be a law. And if you think there isn't romance and drama in the law, if you think that the discovery of a new star, Pluto, Uranus, the stars that are way out to the outermost limits of our solar system. We had the same thing with Brandeis when he discovered a new law. You know, the discovery of one of the stars wasn't seen empirically. 2 astronomers at the same time, one in Europe, one in this country, they noticed the perturbation in the orbit of one of our known stars. And they said this perturbation could only be caused, and they plotted this, can only be caused by an unknown body out there. And both of them at the same time said to the astronomers around the world, point your telescopes at that spot in the skies on such and such a day and give it all the power you've got, and you'll discover this new star that was there. No one had ever seen, no human eye had ever seen the thing before. It was postulated, this new star. A dramatic thing, and what a fanciful thing to point the telescopes and to find that. Just as much drama in the law. Brandeis, when he was a student in Harvard Law School, something just as common as the right to be let alone. You would think that you had the right to live out your life with freedom and happiness and the pursuits under the Constitution, but there was no right. Way back when Brandeis was in law school, it was protected by the law. The right of privacy, the right of to be let alone. There was no appellation of law. There was no concept of jurisprudence, the right to be let alone, the right of privacy. And he wrote this Law Review article way back there, number 4, Harvard Law Review, and said there should be this law. He set it out, and pretty soon there was a case down in New York that incorporated the concept, and since then that concept is in the law of every state of the United States, and it's an integral part of our living today, the right to be let alone, the right not to be molested. This isn't defamation or slander. This is a right not to have your wires tapped. This is a right not to say things about you even if they are true. This is a right not to say anything about a man who gets out of prison even if he was in prison. This right to live alone, and is particularly and peculiarly a democratic right. And with all the majesty of the Constitution, the Founding Fathers' wisdom and everything else, There was nothing in there about that. This law student, not lawyer, law student, conjured up this thing, the right of privacy, and there was the right. It's just as great a discovery as the discovery that was made by Frederick Gibbs, the man that I brought down to Dallas, who invented the electroencephalogram. What a dramatic thing that was, to bring a doctor down to Dallas, who the year I was graduating from Bolt Hall, 1933, I put this man on the stand, and it just sent the hair up in the back of my neck when I put him on the stand. And I said, 1933, were you working with Lennox at Harvard, the great Lennox? You mentioned encephalography, or you mentioned epileptics, and you mentioned the name of Lennox at Harvard. When he was working back at Harvard, Gibbs was back there with him. There wasn't an electroencephalographic machine in the world because it hadn't been discovered, and Gibbs, working with Lennox, discovered the machine. And he's the man that I called down eventually to Dallas and put on the stand. And then in 1964, when we put him on the stand, every major hospital in the world now has an electroencephalographic machine, and it's due to this man's work and this man's genius, the appreciation that all living tissue has electricity, electrocardiogram, electromyogram, and the electroencephalogram. That's maybe one of the reasons, to get ahead a little bit of the story, that's one of the reasons I railed at the end of the lawsuit, part studiously, part deliberate, and part emotionally, because it's difficult for me as a trial lawyer, or to see jurors, no matter how well-intentioned they are, to separate rational action from emotional action. And I did rail when the case was over, and I railed partly because I remembered, and I'll never forget, while I had this great man down there, and it's been my contention in the books that I have done, this is number 30, 6 volumes of modern trials, where I talked and wrote of nothing but demonstrative evidence. Don't tell, show. Don't say in generalities it's a nice day or it's a beautiful sunset, whether you're writing, whether you're trying a case, or whether you're making a diagnosis. What you do if you're talking about the sunset, talk about the rays of the purple shimmering through the opalescence clouds sparkling on the water as they picked up the whitecaps. Now that's something that a jury will remember, that a reader will remember a lot more than if you said that it's a good day or it's a nice day. So when I stood in front of the jury down there with this electroencephalographic evidence that Jack Ruby did have epilepsy, I showed, I didn't tell, and I had the actual electroencephalographic tracings before me that showed in the second burst of electrical activity, showed the 4 and 5 slow waves and the incipient, inchoate spiking and doming in there, that anyone would tell that there was something wrong, and everybody said that there was something wrong, but they just couldn't make out what it was. The only man who had done really this work was Gibbs, and as I was showing this, and I don't say anything more about this trial down there, this is the one thing that tore my heart out, because I remember when I said in argument that they'll look back at us, maybe 10 years, maybe 20 years, maybe 30 years, and how they will pity us for trying to look inside of this poor fellow's brain, how they will say, what crude instruments, it's such an obvious thing. And thinking that and showing this in front of the jury, and the jury was watching it, and I had the tracings there, and I pointed them out to him, and I checked them, and I pointed them out, and then I noticed that the back row of the jury was looking over my shoulder up at His Honor on the bench, and then I saw the front row began to lose interest, and their eyes wandered. And I swung around, I looked up, and His Honor was back there reading a funny book. Now, this is the thing that tears your heart out when you're trying to try a case like this. When I went down to Dallas again, I went down to try the case of an individual. I didn't need any further publicity or bad publicity, and of course there's a lot of bad publicity that attaches to you. You try some of these cases when you're told by the United States Supreme Court to go out and represent the rapist, to go out and represent the fellow who is accused in the small community when the body of the little blonde girl is dredged up from the river. You're told to go out and represent the embezzling insurance company executive. You're told to go out and represent these fellows. And then, and I can recall how many banquets the heads of American bar associations on the Petty Fourth Circuit would tell you, represent these men are entitled to counsel. And as Wendell Willkie said, these men are entitled to counsel, but the communist, when you do represent him, then you get that guilt by association plastered all over you, and then it becomes very moral for the papers. Oh, just so snidely do they associate you with the client, you with the lawsuit. They tell you to do it, and then when you do it, then you get that association. But be that as may, in the Ruby case, we went there because we felt that we could do something for this boy. Boy he is, some 50 years of age, shrunken little Jew boy, J-E-W, Jew boy, and I got that as soon as I got down there. My name Belli, I got that as soon as I got there too. Very adroitly, oh was it cutely done. It was so cutely done when I got into the airport the first time there, the newspapers came up, and Mr. Wade, the district attorney, said, oh, I know this fellow Belli. He's quite a lawyer. He's an international lawyer. He wrote a book about Russia, and that international and that Russia down on the Dallas scene was all that was necessary, and with a Latin name, a name like Belli. And then during the course of that trial, really, one time they pointed to Ruby and they interjected this, that something about Jew boy, maybe he waves his hands when he's talking a little bit more than people of the northern climes. And I said, read that back again. Then Jew boy came out, then Jewish boy, J-E-W-I-S-H, Jewish boy. I could feel the hate oozing out, just like I could see there was integration in Dallas. They have the Dallas City Citizens Council. They have the oligarchy there that gives us something that's good. The end result is good. And I remember I did a commencement address at Howard, the great colored university. And I said, let this be a lesson to you. Sometimes when the method of achieving the result isn't democratic or isn't what we want, then if you get a good result, you're going to regret it eventually. So down there, we saw the same thing. We saw the Dallas Citizens Council saying, let there be integration. And there was integration because they said, if you don't have integration, then we're going to have riots here. It's going to be bad for business, and we're going to suffer commercially, and we're going to suffer economically. So on the following day, there was integration, but it came from above and filtered down, and it didn't have the spirit of integration, because when the world's press came there, this hate that I said that you could see oozing out from the walls. Here you saw it written on the wall. There was a drinking fountain there with a legend below it for whites only, and then over the jail door for whites can visit on Monday, colored people on Tuesday, and throughout the week. The tragedy of Dallas, and again, I'd never done this book if it was just sour grapes, if you will, or if it was in destructive criticism of this great American city. It was that I thought I could do something constructively. And I tried to point out, as Warren Leslie in his book tried to point out, and John Bainbridge in his book tried to point out, that here is this great city, unconsciously they don't know what they do. They said that Belli shouldn't have tried this case, that they should have gotten a Dallas lawyer, that they tried Belli instead of trying Jack Ruby. My friends, 23 out of the 24 cases that were tried before the Jack Ruby case all ended in the electric chair. They were all tried by Dallas lawyers, and those lawyers asked for mercy too. And in every one of those cases, the verdict came in not much longer than the 1 hour and 1 hour and 50 minutes in the Ruby case, but in some of them the verdict came in 3 minutes, in 7 minutes, and in 5 minutes. Now, when you have that in the community, you have real problems. These people consciously are good people. These people thought that they could give a fair and square verdict. But here's a problem that we have, and I wouldn't change it. I don't know what the answer is. You don't know the person who sits next to you. You don't know someone you've gone to class with for months. You see something in the paper about someone you've known. Well, I've known him. Good heavens, I wouldn't have thought that he would have done a thing like that. Men get by the Marine Corps. Oswald, who was a lone assassin, no question about it, no connection between Ruby and Oswald. You can take my word for that, and I think I know about as much as anybody living about those things in the exhaustive survey that we made. But you don't know who your neighbor is, and maybe we never shall, and I wouldn't have it otherwise, that your neighbor has to have psychiatric tests, has to take a Rorschach test, and have his telephone tapped. But when you take 12 people that you've never met before, let alone gone to school with them, don't know, being with them daily, you take 12 people sitting in that jury box, and you ask them a couple of questions, and the questions that you ask them are for all eternity, because they're questions, will you kill a man? Legally, that's capital punishment. Or are you against capital punishment? And you have to take the answer that they give. You get certain little telltale signs. If they say, yes, I will, and they move their hands, Bob Considine and I were watching this. I told him to watch it because I've noticed it over the years. they're not telling the truth, if they keep their hands still like that when they answer it yes. Well, these are little psychiatric gimcracks that a lawyer gets, like when a jury comes back before you get the verdict. When those 12 jurors come into that jury box, if they go in and they keep their eyes averted from the plaintiff, if they won't look at the plaintiff in the civil case, he's lost it. If they won't look at the defendant in the criminal case, boy, you know you've had it. You can just tell as they come in there, and if they look at you, they don't have to wink at you or anything like that, just look at you. You know that the verdict is yours. So, Dallas, how would we know what we were going to get? Well, we had one indication. We had 178 talismen there who came in, veneremen, jurors. And from the 178, we had to pick 12. And out of this 178, there were 2 Jews, 2 Catholics, and 2 Negroes. And 172 were all Southern Baptists. I haven't a thing against a Southern Baptist, a Catholic, or Episcopalian, a Negro, Italian, a Jew, or anybody else. But I want a jury like I want my city. And I said this up in Montreal the other day. The thing that makes Montreal a great city, that makes San Francisco and Chicago and New York a great city, and makes this country great, is that it's a melting pot. You have the tolerant and the intolerant. If I were given 12 jurors who would all go my way and all say that they would give me a big sum of money for my plaintiff, I would get less from that bland jury than I would get if I had 6 men my way and 6 men against me, because then they would go out and the sparks of conflict would shed the light by which ultimate justice would be seen. And that's what you have to have in a jury. A jury is a microcosm of a city. And if your jury is bland, and if it was like it was in Dallas, then your city is going to be the same way. Now I see it's time, and I have successfully talked about everything else, but that which is in the book, which, as my publishers say, is a very good thing to do, because you'll all rush out and buy the book. Thank you very, very much for having me down here.
You have questions, Mike?
Yes, sir.
As soon as those return to class who wish to, Mr. Belli will answer questions. Let's just give him a few minutes to settle down.
Spackman and Good.
Spackman and Good?
Yes, upstairs in GCA now. If there were more water, I could tell you that. Last thing.
I'm doing something on it right now.
Huh?
I'm doing something on it right now.
On the Spackman Good page?
No, on right private.
On the right private. Well, this is the extension of that. See, I've coined the expression now, for the first time, trespass to personality. That encompasses right of privacy, defamation, libel, and slander. And it truly is a trespass to personality. And we're going along hand in hand with science, because science now, with the Rorschach test, will be able to pull these things out. I can show recent sex comm, for instance, by someone talking to children. And in this case, if it comes down and is affirmed, what we're going to have here is a tremendous weapon for obscene literature, obscene comic books. We don't need to censor it all. Let the parent who feels that the child is being damaged by reading these comic books, textbooks, and so forth, sue the distributors. And that's the best way to stop it. Don't get any injunction. The criminal case is ready to
Answer questions from the audience. We'll now accept questions from the audience. I'll try and repeat them. Would you please stand up and make concise statements?
Yeah.
Anyone? Sir, would you please repeat it?
I'm sorry. Well, I held back progress for about a year, I guess, successfully, and cost the telephone company about $5 million. I thought that all-digit dialing was utterly and completely unnecessary. I thought it was a Parkinson's law. You know, some guy in the corporate monkey tree comes up with an idea, and he can't stay in that level because someone will climb over him. He's got to keep climbing on up. And I do think that this digit dialing business was something that was conjured up back east, and they foisted it on us. And of course, I guess I'm a nonconformist. I don't say that with a great deal of glee. I say more in the sense that I'm an individual, and I just hate to be conformed. Now, I've got a delightful telephone number in my office, and it was their own fault they gave it to me. The Belli building, my building, was built in 1849. It's the oldest building in San Francisco. So they came over and they gave me Yukon 1, 1849. Now, I hated to give it up. I felt that going through all of the evidence that they had, that there was absolutely no reason for giving us all numbers. We had, all these specialists came in and they told us that for the next 20 years they could give telephones to everybody, even put them in convertibles in Tibet, and we can have the same system and we wouldn't need numerical numbers. And I think we proved that. And then they brought in people. They brought in a Stanford professor, and I don't say that in derision, of course, but they brought in a Stanford professor who was wrong, incidentally, and he said, why, you can remember numbers a lot better than you can remember letters and numbers. And then we started kicking him around, and he said, well, you know, really, what we're trying to do, we're trying to get you to write numbers down so that you won't get wrong numbers when you call. Well, those are the calls from home, you know, that you get 5 or 10 of those, and it ties up the lines, and they don't get any extra revenue on those things. Well, I just don't think that there was any need for the all numerals. I don't think they proved a case on the thing. We did get a temporary injunction. As they say, we held up progress for some time, and then we lost out. We had some delightful, not trial antics. I think we did them very seriously. I brought in some bartenders, I brought in a bookie, and I brought in a madam, saying that it's very difficult to remember all of these numbers. And I asked one of them, could you remember with all your girls, could you remember 84792, or could you remember if her name was Rosie or Pussy Galore, or whatever the name was there? From James Bond, of course.
Yes?
Yeah.
The question is, does insanity indicate less guilt vis-a-vis the Ruby trial?
See, insanity, to answer you categorically first, insanity connotes no responsibility. So you can't say that guilt has anything to do with insanity. Once a man's insane, then guilty or innocent has nothing to do with it. The best illustration of that in California now, if a man is insane at the time of trial, then the trial is put over until he regains his insanity. I had Donald Streeter, one of my first cases years ago. Donald Streeter shot somebody. He was heard voices. He shot this man over at the Richmond plant, Richmond oil plant over in Alameda County. After he shot this man, he was apprehended. They brought him to trial, and he sat next to me he had another lawyer first. And he sat next to the lawyer counsel table. He couldn't assist his lawyer in the defense. He was completely psychotic. So they didn't have a trial. The question of guilt or innocence didn't enter into it. They didn't have a trial. They sent him up to Napa. Well, about 5-6 years later, I was called. I brought a writ of habeas corpus. I brought him out of Napa on the grounds that he was now sane, therefore he couldn't be held in Napa. But he couldn't be released because there was still this indictment from about 5-6 years hanging over him. So then he's brought back and he stands trial, and the question then is, was he insane at the time that he did the act? Which act was about a week or so before the time that he was sent up to Napa from the court. Well, the jury was out for 1 minute, and they said obviously if he was insane when he was brought to trial, he would have been insane at the time that he did the act, which was just before it. He's now recovered his insanity, so he goes out, if you will, scot-free. No question of responsibility or otherwise. Now with Jack Ruby, there was no doubt in our mind that he did shoot Lee Harvey Oswald. And I wasn't doing technicalities of the law. And I remember one of these questions that was asked me in the Playboy interview, what do you think about technicalities of the law? And I said, sir, don't talk to me of technicalities of the law until you tell me just what you're talking about, because I'll talk back to you and say, do you feel at trial by jury the right of habeas corpus or coram nobis, or the right to be confronted with your accusers? All of those things from which it caused us to leave England. Those are what you call the technicalities of the law. I don't want any inroads. I would just as soon now and then have a guilty man go free in order to keep these tremendous things that give us protection. And particularly with so damn many politicians around, all trying to rise up over someone else's shoulder. They always come up with another law, and they think it's popular to say, oh, it's very popular, in fact, to say, oh, there's a lot of guilty men going free because of technicalities of the law. And the layman will shake his head without thinking, say, yes, that's so. And then they start talking about truth serum. Then they talk about wiretapping. Well, you let them enter my castle, my home. Then they're going to enter my mind. And then when they see what I think, then they'll want me to conform. Wiretapping, truth serum is the first step to getting into my mind and to make me conform to what Big Brother and what they want. That's why this thing is so damned important, this technicalities of the law. That's why I felt so strongly about Bobby Kennedy and Mr. Hoover, a friend of mine. And you should read the FBI, that no one knows, the book by Cook. That's why I feel when someone talks about technicalities of the law, let's see which technicality it is. And I think that most of these laws that are born from the law and from the judges are good laws. The laws that are the silly laws sometimes are the laws that are made by, with due respect, the layman at the legislature in Sacramento. Now, Jack Ruby did shoot Lee Harvey Oswald. He didn't know Lee Harvey Oswald. There was no connection between them. The man's name was mentioned here, whom I debated in San Francisco, and some 1,500 students came over from the University of California. They weren't they weren't communists, they weren't Birchers, but they had some strange ideas, and there were some very strange ideas in the audience in New York when I debated. And I was really traumatized, and I was really frightened in that. I would mention the United States Constitution, or I would mention President Kennedy or President Johnson or the FBI and the CIA, and they'd boo all of those. And finally, I did talk to one of them. Don't you want cops? Yeah, we want cops, but we don't want any FBI. We don't want any government. We do want some sort of law and order, but let's get rid of all of these hierarchies. Well, I don't know whether it's a feeling to get back to state rights or not. I think that Mr. Lane has done a tremendous disservice to us by parlaying rumors to the point that he now says, what? Does he say that Oswald did not do it? Does he say there was a conspiracy? Unfortunately, where he's spoken in Europe, if you were to go to Europe now, you'd find that 80% of the people over there would say that there was a conspiracy between Oswald and Ruby. Who were the conspirators? They will tell you, over 50% will tell you, that it was the CIA, the FBI hunt of Dallas and President Johnson of the Texas Palace Guard. This has done more to hurt our image abroad than anything else. If that were true, it should hurt our image. If that were true, I wouldn't be standing on this rostrum. I'd be back at Congress or barricading my door if I couldn't start from someplace and know that what they did in the Warren report, they'd take fingerprints. Well, they'd take the report from the Dallas cops. All right, we may not want what the Dallas cops say. Heavens knows I'm no a Dallas cop lover. But when I get the Dallas cops report, then I get the FBI report, then I get Mandela up in New York, and I get a report from the laboratory at Northwestern, all of these people who are rival institutions. And when I get a report that's as objective as this Warren report, then I've got to believe that Warren report. And I would say right now, if that Warren report were errant, if Justice Warren and our duly elected congressmen and senators and the men that sat on that report, if they weren't telling us the truth, and if this were a cover-up, and that there was something going on that we didn't know about, I would tell you, throw away your books and forget about going to your classes, because this country is not worthwhile living now. Isn't that true? Isn't it true that if there were a conspiracy and if it was kept from us, isn't it true that if Oswald and Ruby acted together and Johnson acted with them and the CIA acted with them, what is the future in store for this country? I will tell you that I am shocked at some of the things that I read of the Unseen Government, the book on the CIA. I'm not shocked at what I read in the FBI that no one knows, because I've always held Edgar Hoover and King Farouk on a par. But we do have our federal courts, and let me tell you, as long as we have our judiciary, and as long as we have our federal courts and our local judiciary here, then You're not going to get any phony report, because there are ways of bringing that into court. There are ways with the libel, slander, defamation of doing something about it. Now, you cannot debate a man who says that Mary Surratt, you remember in the Lincoln assassination, was innocent, because they can pick up rumors. You cannot disprove them. Now, I cannot disprove the contentions of Mr. Lane, because, number one, I don't know what his contentions are. Is he saying that Oswald was not the assassin? Or is he saying that Oswald didn't get a fair trial? Well, I'll tell you, if he says that Oswald didn't get a fair trial, I have to agree with him. And I would say that any dead man who does an act, it's difficult to prove him guilty beyond a reasonable doubt and to a moral certainty. I will tell you that a terrible thing happened down in Dallas, as happened with the assassination of McKinley. Slogzog, who was the assassin of McKinley. And this is the reason I have the fights with the Bar Association. It's all for surface, and it's not for substance. The other day they said that this outburst, if you will, after the trial, where I spoke out and spoke truly, and I said this is a railroad and a kangaroo court. Oh, then immediately investigate Belli, but no one investigate the substance of his charges. In the assassination of McKinley in Buffalo, Soglov was the assassin. When it came time for him to go to trial, and this again, why do we always look so bad in these big cases? When it came time for him to go to trial, the Bar Association appointed 2 retired judges to represent Soglov, and you ought to read the argument. They both talked for 10 minutes. 8 of the 10 minutes were devoted to an apology for their appearing as counsel for this man to save his life. 1 of the 10 minutes was devoted to a eulogy of the martyred president, and the other minute was hacking and hawing about the defendants that they were representing. It was an atrocious thing, an atrocious appearance. And the same thing happened down in Dallas. As the Warren report says, Oswald couldn't have gotten a fair trial in Dallas. But damn it all, that's a dead man. That's an assassin. I don't want to shed any tears over this assassin, even though this man was a psychotic, and I think it would have shown in his record, and that would have been the defense. What I want to shed tears over is a living man who was a complete psychopath in the Dallas County Jail, who was lying on a tick mattress out in the corridor with lights over him 24 hours and 2 guards there. And the family doesn't want to send him to a mental institution in Texas, because in this great state, with these great people, and with the great hospitals and museums and money, and all of this material arrogance, they are number 50 in mental institutions in the United States. That's from care, guards, support, medical, and so forth. And they're afraid to send him there because they feel that he wouldn't live if he got in there. We've had the Warren report on Oswald. Now let's have a Warren report on Ruby, so that these things can't happen again. I've tried to tell some of it in the book, what went on there. Read that thing, and I think that you will agree with me that I should have turned in my shingle if I didn't stand up after this trial and some of the things that went on in that case, asking to see a record, and the judge saying, well, ask Henry if he give you the record, Henry being the district attorney. I said, Henry, will you give me the record? No, I ain't going to give you a record. The judge, he won't give it to him. He said, well, nothing I can do if Henry won't give it to you. So I say, Judge, why can't I see the record? And he says, Dallas City Ordinance won't let you see the record. And that's the way it went. Boy, when you see that appeal brief, I hope that they write a long opinion on the thing so we can see what it is. But there, after standing in front of a jury at 5 minutes to 12 on a Friday night, and the press being in that courtroom all day, and having hard-boiled eggs and bananas and oranges and apples and old Marca Petrie cigars and unwashed Bulgarian newspaper men in there, it smelled less than Chanel 5 when I got up to argue, and had all of those lights beaming down. And then the final touch was to see the elite of Dallas coming in with tails and dinner jackets around the wall. And as I got up to go from counsel table, at 5 minutes to 12 to argue for this man's life, and given over 50 minutes, 50 minutes to argue for a man's life, I looked out there. Boy, it looked like the old Roman Colosseum to me that my ancestors probably sneaked out of or tried cases in. Don't know which, but I walked from the counsel table over to the jury rail. I remember commenting that it took me It took me 2 years to walk over there, and it seemed like it was 5 miles, and I was saying, can this happen in America? And then I argued, and as I started to argue to that jury in that night, here was a defense. It was a sophisticated defense. It was the only defense that I could put in. Here I was trapped, and here this boy was trapped. And this is the thing. This hasn't been told. I try to tell it, of course. I'm opinionated, sour grapes, whatever. I can't tell my story. The organization is supposed to represent you because it represents every lawyer in the United States. They haven't said a damn thing about the Ruby case. The only thing they've said is kick Belli out of the American Bar Association, but don't examine into the justiciableness of the charges. And did they examine into the Sacco Vanzetti or any of those cases? No. It's to take the individual unpopular lawyer and look after him. Well, when I stood up there and I saw that jury lighting cigarettes and chatting back and forth as I tried to argue for this man's life, and then the next morning, knowing what I had had to do, and in my mind, that this judge reading the comic book as I was trying to show this epilepsy, and here's what we got embroiled in. Do you know that this Jack Ruby was home in bed on the morning of the shooting of Oswald? He gets a telephone call from the little striptease that she's pregnant, her husband's no good, she needs money for the home. Would Jack send her $25 out of the goodness of his heart, or chauvinistic, misguided proprietorship of owning a striptease joint? I don't know which. But he gets out of bed and he goes over to the telegraph office. And I often think every day that we get out of bed and walk down to court, that roulette wheel is spinning in the combinations for the different circumstances coming up for us. He gets down to the telegraph office. He walks into the telegraph office. He sends her the $25. He's got $2,000 in cash in his pocket. He doesn't believe in the Bank of America. He believes in cash and carry, and particularly when he had income tax to pay. I think that that's probably not without reason, material reason. And he had a gun in his pocket, and they all carry guns. And I was criticized for saying, well, hell, they all have guns in Dallas. Neiman and Marcus has his and her guns up there. And I shouldn't have said that. But he goes into the telegraph office. He comes out. He's got the gun in his pocket. And he sees a crowd about as far as that end wall from where he came out of the telegraph office. And out of curiosity, this is factual, this is objective. Out of curiosity, the guy goes down there because he thought that he was going to be transferred, Oswald was going to be transferred at some other time. This fellow, remember, is a very tremendously emotional man. He'd gone down the middle of the night before to take Polaroid pictures of the signs impeach Earl Warren. He's over with his sister crying, and they're carrying on something terrible. He has a tremendous emotional upheaval. But this morning, none of that, no motive or anything else. Comes out of the telegraph office, sees the crowd, he walks over to the crowd, and he walks in, that roulette wheel, and he walked in. Of all of the people in the world, that was the one fellow that shouldn't have been let in, and they did leave him in. Why shouldn't they have let him in? Well, number one, because he had a gun, and he always carried a gun. Number two, he was a tremendously emotional man. Number three, superimposed upon all of this motion was this psychomotor variant epilepsy. And here is the sophisticated defense that I had. But it was the honest defense. And if I didn't tell this to the jury, and if I didn't abide by this, if I'd have gone in there and pleaded him for mercy or something else, I wrapped that plea up, and the argument is in the book, and you can read and see what we did on it. But if I'd have gone in and done anything else, then I should have been disbarred later on, because people would say, why, here you've got a man whose mother was in an insane asylum, paranoid senility, when she was in the asylum. You got a brother who was in an asylum, and you got Ruby locking himself up for 30 days, one time in a hotel, threatening suicide, and then you've got another time where you have him bouncing someone's head on the deck and waking up and saying, what am I doing, what am I doing? And we had these little fugue states, these little hiatus of consciousness, little blackout. So here's this man with all of that, this brain damage, and with this terrible emotional state, and here that wheel really spun. And this is the sophisticated thing. Oh, they ridiculed it. They ridiculed it. When I said there was a blackout then, and the district attorney got up, and it's an awfully tough thing. A cartoon can devastate a person, an adroit cartoon, and so can just an illustration such as, oh, you say that he had a blackout. I know, I'm familiar with those blackouts, says the district attorney. That's like the little blonde girl who's standing over the body of that rich oil daddy of hers with the smoking gun saying, why, the little old thing went off, I don't remember a thing. And of course, that paints that picture that you get in the newspaper. I'm not guilty by reason of insanity. That's the first thing that the clever lawyer thinks of. That's the first thing that you're going to try as a defense. But sometimes, and many more times than you realize, it is true, and it was true in the Ruby case, because here's what happened. He got down there, had the gun in his pocket, and here comes Oswald out. All of these combination of those circumstances, but superimposed upon that, this highly emotional man, and then, at that time, all of these flashlights began to pop. Pop, 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 and Klieg lights and everything went on, and it smacked this guy right in the head. And he was emotional enough almost to have done anything, but I think he would have kept his restraint if it were his own emotions. But when he had all of those lights, that's the way you induce clinically an epileptic state of psychomotor epilepsy. Ask your psychiatrist, look in the books. If you want to superimpose a state on a man who is inclined to epilepsy. Now, this is the type of epilepsy where you forget what you're doing, but you can do purposeful acts. There's a grand mal, the classical kind, where you fall down and froth at the mouth and all those gross things. Then there's a petite, which is less in degree. But then the psychomotor, you don't do anything except act the same way that you always act. You go into a bank, you take all your money out, you go to Honolulu, you squander it, then you come back and you wake up on the plane on the way back and say, where am I? And that goes in degrees down. The school teachers are beginning to find it out. That goes in degrees down to the children who are reciting it in the middle of a recitation. There'll be a hiatus, or there'll be a blinking of eyes, and we're getting more and more of that all the time, beginning to appreciate what it is. Now, you read about that, and you can see what happened at this time. Ruby is there. These lights went on. He went into the same state that he had been in, and we had it on many other occasions. And he blacked out from the time that he saw Oswald. He did the purposeful act. Whether the germ was there before, it wasn't at the time that he did it, and that's criminal responsibility. And he didn't remember anything until he was down on the deck. And this I know so well because after when Earl Warren went in to see him, he said to the Chief Justice, I did this for Carolyn, I did this for Jackie. Well, that would have given motive, that would have given purposeful act, and that would have made him a candidate for capital punishment. But I remember he told me the same thing, too, when I was in the jail with him, and I said, all right, Jack. And as we say in the book, we start a chapter by saying, I'm guilty, why are we fooling around, Mel? Why don't we go in there and plead guilty and get it over with? You know I did it for Jackie and Carolyn. I said, all right, Jack. As a lawyer, I've got to tell the judge what you did. So now you sit down and tell me exactly what you did. So he says, all right, I went to the Western Union and everything. Brings me right up to the time that those lights popped. And he can't tell me about the lights popping. I saw that on TV later on. He brings me up to that point, and I say, all right, did you aim at him? Well, then I get confabulation. Now, confabulation is filling in. Confabulation is something that's told to you later. The mind abhors a vacuum. We hate to be unconscious, even to have a tooth pulled or your tonsils taken out. There's even a name for people who sometimes dread to go to sleep for being out of this world, being dead, being transiently dead or transiently unconscious. The mind abhors a vacuum. This man would rather stand as a murderer than to admit this complete insult to ego. He doesn't have the cognosco ergo sum. I know, therefore I am. He's no longer in this world. And that tremendous insult, this man was willing to tell me that he did this and he was a murderer. And of course he couldn't appreciate the confabulation that filled this in. So I took him through, what did you do next? How did you get down on the deck and so forth? And he was blacked out. He could not remember one thing during that period of time. Now that was taken, they took him through that, the psychiatrist, good psychiatrist, took him through that. I watched them take him through that. I took him through that, and there's nothing that came back except what was given to him and what was filled in. Now that's the defense that I had to give. That was the honest defense. That was the true defense. This man did commit this act during a time that he was unconscious mentally, but physically capable of moving out. moving around. Now that's psychomotor epilepsy. It happens frequently. People cash checks. People do strange, bizarre acts. It's an amnesiac act. Don't know where they are. And they're not responsible under the law. So I had to try and convince this jury to that. And the difficulty of trying to convince that jury when all during this time the judge every now and then would read a comic book or shift that cut around from the left side to the right side or light up one of those big black cigars. And that's the only thing really distracted me. How that thing could be lifted up. I thought one time that he was going to start off a rocket in the courtroom there. Well, we'll talk any more about that, yeah. They're in the lab. Yeah. Where are the great discoveries? I talked about these great discoveries in the law, and that we are keeping law consonant with science. And McNaughton's rule is an archaic doctrine. Where are these great discoveries in the law? These great discoveries in the law are in the psychiatrist's laboratory, waiting for him to tell us more about the human mind, and he is telling us some things about the human mind. Now let me give you another. McNaughton's rule, a test for insanity is, if you don't know the difference between right and wrong, the nature and consequence of your act, then you're not criminally responsible. It's a barbaric rule, because there are a lot of people in the insane asylums who know the difference between right and wrong, but they're locked up in the insane asylum. Now, it's very difficult to categorize or departmentalize human conduct or human responsibility to say up to 20% of remembrance or 20% of conduct that you can remember, you're going to be responsible. Beyond that, you won't be responsible. But let me give you one illustration to show how we're beginning to measure some of these things. I don't know if this is a solution or not. You know, we've only gotten to the cortex of the brain, the outer covering of the brain. We haven't gotten into the depth of the brain to really get any process of accuracy or thinking. We know where the brain is. Way back, the old phrenologists tried to say that part of the brain did this, part of the brain did that. This case that I tried in the Virgin Islands the other day, I brought a good neurosurgeon from Puerto Rico over to St. Thomas, and we showed with electroencephalographs, and we showed precisely this man had a halting talk. We showed which part of the brain had been damaged because this doctor had been in there and lifted up the piece of bone from that exact part of the brain that had to do with speech, with seeing, with reading, with talking, and we could show which part had been damaged. And then we got the electroencephalogram, and we showed that these leads right over those areas there were the ones that gave us aberrant readings. Now, here's how far law has gone. In this trespass to personality case that was the name that I've given to a tort, it has to wait baptism, and it has to wait legitimacy before it goes through our appellate courts, but I have no doubt that eventually trespass to personality or some such tort will be recognized. Here's what's happened. You know, in the law you have first a problem, and we've had it for years and years, that a person standing over in that side of a room, an automobile goes over here and runs into another automobile, and terrible accident, people lying all over the street dying. This person sees that. This person over here goes crazy, or in the old days had a miscarriage or something happens to her. And then this person over here wants to sue these people for negligence for doing that wrong over there. And we've said in most of the jurisdictions that this person couldn't, because it would open the door to fraud. Well, now, that's because we didn't have any way of determining really whether this person over here was traumatized by that act over there. So we conjured up the fiction. There has to be some touching. If there were a little touching of a piece of a wheel or something flew over there and hit her just minutely, then she could say that all of these other things were the consequence. Well, I suggested without arguing to an appellate court that if you needed the touching concomitant with the psychic damage, that you could say that in order to perceive, in order to see over there, your eyeballs must have had some waves, some atoms that came from there, and there must have been something material that touched. I didn't get the chance to argue that in the appellate court, for which I think the justices might have been thankful. But now Now we're going beyond that, because in this case that I tried, Spackman and Good, and you'll see it in the appellate records coming up now. In that case, we had someone who gave aberrant, abnormal sex instruction to children. They took the old Summerhill, the school in England, they took it out of context. They said that self-abuse was all right if you didn't think it was wrong, that brother and sister relationship was all right if you didn't think it was wrong, and so forth. And they noticed that these children were having bad dreams. He didn't lay hands on them, he didn't touch them. No molesting at all, entirely mental. And they noticed that there were some problems with the children, so we got a clinical psychologist, not psychiatrist. The psychologist, you know, transfers your thinking over to clouds or curtains or to ink blots. And then we've done enough of those so we can tell what is normal and what is abnormal. And then after he does that, he gives that to the psychiatrist. Then the psychiatrist is purely subjective and introspective. He takes a case history, he examines into the mind by way of questions. The psychologist doesn't take a case history, because he does his the other way. He does it, projects them, and the psychiatrist introspectively. Well, in this case here, the clinical psychologist and the psychiatrist told us that their professions now had achieved such accuracy that they were able to tell me that these children had sex damage done to their psyche. And they were also able to tell me that that sex damage was recent sex damage and not sex damage when they were 5 or 6. Now, my law then is going to take hold of this scientific diagnosis and taking that on upstairs. And now, because the science can tell us these things, now our law is constant with our science, and we've conjured up this new law. I think it's a very dramatic thing. I know that at Yale, Schaefer now in Yale, the psychologist, is now with his Rorschach testing able to tell you where brain damage is in the brain more accurately than we can even with the electroencephalogram. You know, it's like the X-ray that takes the currents up and we can show what part of the brain is damaged. Schaefer by Rorschach, by ink block, by asking you questions and getting to project yourself, he can give you the area of the brain that's being damaged. So, as we're progressing psychiatrically and psychologically, we're going to progress in the law. The McNaughton rule, barbarous. It's the law in most of the jurisdictions. There's very little we can do about it. In this case here, every case that I try, I throw it in the hopes that we can beat it upstairs, but I don't rely on it completely because I know that's the law by which I'm bound.
Would you like to quit or?
Oh, no.
Over here? Let's spread it around a bit. Would you please sit down? Over here?
It's not the short question, it's the long answer that takes the time.
Asking for a comment on the aggressive newspaper man.
We've got to have freedom of the press in this country. I think that's the one thing that makes me so sure that the Warren Report is accurate. That's the one thing that makes me so sure that politicians are going to behave themselves, even if we vote for the wrong man, locally or nationally or wherever. So any bridling of the press I would view with a great deal of caution. Of course, our law is being changed with the defamation now. Justice Black has always said on the Supreme Court that freedom of speech means freedom of speech, and there is no libel and slander. And they've come, well, I haven't gotten that far yet, but Sullivan in New York Times is a case that fooled with that and said, for instance, if you can't stand the heat, stay out of the kitchen. If you're a politician, you have to have almost unbridled. They have unbridled license to castigate you or do anything else. How do you handle a big trial like this? Well, in England, if the newspaper men so much as suggested that the man was guilty beforehand or suggested any of the testimony, not only would the newspaper reporter be thrown in the clink, but probably people such as Beaverbrook would have gotten 6 months and a tremendous fine. The only thing the Englishman can publish is the Q&A after, question and answer after the hearing. In this country, they do everything. They do everything. They came up to me and they made a suggestion. Don't you notice how Ruby looks like Oswald? They have the same facial appearances. Now, you've got some information, haven't you, that they did have the same father? Now, you can admit or you can deny it, and we'll publish whatever you say. Now, these are the rumors. These are the things, and the foreign press had a field day because they weren't able to do these things in their own home. So in our country, they just took license and liberty. What can we do? It's awfully difficult. I do feel that we should allow some television in some of our trials, but let's not start with the Jack Ruby trial. Let's not start with the big trial. Let's start with some of the little trials. Let's show how in our daily trials we're making our law modern. We're doing such great things in the law. How with discovery before trial? There's not a lot of this technical stuff, the whereases and the rest of that stuff. If you do a lot of that old common law pleading, the jury would laugh you out of court. How fast we get a doctor on the stand and off, how we get the aerial photos, how we get mock-ups, how we get experiments, how we do now in 2 and 3 days what used to take us 3 weeks to do, how we get ultimate justice, and I think you'd be very proud of your law. Now there you'd have to have television cameras in the courtroom to see this. But let's not start at the top in the Ruby cases, because there you just lose complete perspective. You get it completely and utterly out of context. We've had more assassinations and attempts at assassination in this country than any country in the world. God forbid that there ever be another thing like this. But what are you going to do with the two conflicting interests? The right of the individual, such as a psychopath, Oswald, as compared with the right of the whole country to know. Now, I remember I was on trial down here in Superior Court trying a murder case, and it was about 20 minutes after 12 when my defendant told me that there had been this assassination. And then the rumors started filling in. One of the rumors said, well, it was a colored man did it, and I said to myself, oh God, let it not be any ethnic group, a Jew, an Italian, a colored man, or anybody else, because we've had enough trouble with the civil rights. There'll be riots, there'll be problems here. So then I wanted to know, and I guess everybody in the United States wanted to know and was entitled to know. That's our right of freedom of speech in this country, and we're entitled to know. But on the other hand, there's the right of that individual. These things are all told. The questions, do you have a case against him? Was he the one that killed the president? Or do you think there are other conspirators lurking around as part of this? They say, no, he was the only one that did it, and we've got a case against him. Well, I think that at least satisfied some of us in a tragedy that we shared nationally. It satisfied some of us. You know, Lyndon Johnson, after the assassination, got in the presidential limousine, and the Secret Service made him lie on the floor. And they wouldn't announce the death of the president until that he was leaving until he got out to the airport, because they thought there might have been some conspiracy to do away with the vice president and the cabinet. Remember, that's the thing they tried to do in the Lincoln assassination. So I think the people in the United States had to know these things. But when they learned these things, then the right to a free and fair trial by Oswald was completely, utterly dissipated, because you couldn't get jurors who didn't know about it already. So you have the two conflicting interests. I think that this is the sort of thing that should be discussed in a Warren Commission on the Ruby case. I think this is the sort of thing that should be discussed in determining whether, for instance, people who see an act on television are witnesses so that they can be jurors. Now, I contended that anyone saw this on television was a witness, and the code says witnesses may not be jurors. I wasn't concerned that Ruby shot Oswald as far as the case goes. We knew that. The only thing we were concerned with was looking inside of Ruby's mind. And really, I was the only man at that time who had the privilege of doing this, and I knew what I saw, and I didn't want my jurors, having seen this on television, a little man coming out of the crowd purposefully, and having them later on in the jury room saying, I saw it, and to me, the way he did that proves that he deliberately did it and he wanted to do it, and that's a lot of hogwash about the blackout. See, in their mind, they may feel that in the blackout you'd have to go around in a stare. I thought that the evidence should come from the experts, should come in the courtroom, rather than this edited version on the television. So I can't answer your question, and that question remains the two conflicting interests, freedom of the individual and freedom of press for all of us. No, I've never criticized the jury system. What I criticized in Dallas, I probably should have said when I said thank you for your verdict of bigotry and justice. I should have added, for you knew not what you did, and that's what I really meant, because I don't think they knew what they did. They came back self-satisfied. It was this unconscious feeling. It was like the Manchurian Candidate, that there was a transistor in their mind, and if you'd press that button, and you'd get that answer. It was protecting the Dallas image. That's why this case should never have been tried in Dallas, because these people had to protect the image of their own city as well, and as at the same time try Jack Ruby. Had this been tried in Fort Worth or San Antonio or Corpus Christi, it had been a completely different result. We'd have gotten a jury who had been consciously objective as well as unconsciously objective. The Dallas jury couldn't be unconsciously objective. I certainly favor the retention of the jury system, and that from a man who is now trying most of his cases before judges, because the insurance companies have infused through the magazines, Reader's Digest and these other magazines, into prospective jurors' minds that they're giving too much money in personal injury cases. They're saying your runaway juror idea of giving a human being $1 million, the idea of giving a paralyzed boy, such as this little fellow that I represented down here, the little boy in the polio case here, giving him $605,000. So they told jurors, vote lower awards because now this money's going to come out of your pocket in higher insurance payments. And I've seen that take its toll in the jury room, even among our good objective jurors here in Los Angeles and San Francisco. But the federal judge and the judge knows what the loss of an arm or an eye or a leg means, what the economic loss of a wage earner to a family is and to the community. He knows the cost of hospital doctor bills. And the federal judge is the one now who's giving the highest awards. The other day in Philadelphia, in a suit against the United States, this judge, a federal judge, held against his employer, the United States, in a malpractice case where they had injected some radiopaque substance in the man's face, $725,000. Now this case that I tried down in the Virgin Islands, I went down there, I saw 12 colored people sitting as jurors, and the defendant was a colored man. Now if I'd gone to Rome, there were 12 Italians there, and the defendant was an Italian, and I had a Norwegian, I would have gotten that out of the jury and to a judge, so I did. There was a colored judge there, and one of our great judges, Walter Gordon, graduated from my alma mater and went to my law school, and who was on our parole board, and who was one of our first greats on All-American. He only got mentioned because at that time we don't have the equality we have now. He should have been full #1 All-American. So this was a colored judge, and I took him because I knew he could be objective. He had the training for this. So that brings me to the answer. Do you think because judges have better training that we should have them try our cases, or go out into the marketplace and get people who don't have training? Even though now and temporarily I'm trying my cases before judges, every time I say retain the jury system, because that's the best reason for keeping these federal judges and these state judges and giving adequate and consonant awards. I criticized the jury down in Dallas. I lost my objectivity. The Rubies fired me, or I got out of it right after they made the suggestion. If I were they, I would have fired me too, because once a lawyer loses his objectivity, then he can't do anything for the cause. You know, my greatest asset to my community is the thing for which you criticize me. You say that I'm facile mentally, ambidextrous ideologically. I can take either side. Well, that's what you should want. I'm a friend. Lawyers historically came from friends, a friend representing me. Because in court, I'm tongue-tied and I can't talk, so I get my friend. And then grew up the lawyers that spoke for the man. But you want him to be as objective as the surgeon. You don't want to know where he got the tuberculosis. You want to cure the tuberculosis. You don't want to ask a lot of questions. What ideology did you have to make you embezzle this money? You want to represent that man. So when I got so objective in this case that Ruby became my friend and I associated myself too strongly with him, I think I lost all my value. Again, the value in a lawyer is that for which you criticize me the most, that I am for hire. I'm for hire for anyone who will come to me, sometimes with a particular case that I think should go to the Supreme Court. Not a cause, but a case, an individual. We'll do these clinically. We'll do these for nothing. And the lawyer does as much clinical stuff as does the doctor. Period. I think we've got a great Supreme Court. I think Earl Warren is a great administrator. Now, does that mean that I deliberately don't say that he's a great judge? I'm not concerned with whether he is the greatest judge, an Oliver Wendell Holmes, because we've got enough men on that court and enough clerks who know the law. I say, too, in the same breath that I say that this is a great court, that I can't deny that it is the second legislature in Washington. But I think that it has done a tremendous job. It has interpreted the Constitution honestly. I think in the prayer decision, these men would have all gone the other way, but they felt that they had honestly and objectively to give the decision that they did. Some of us are pretty disgusted with some of the antics of Jehovah's Witnesses, but we must give respect to Jehovah's Witnesses. I was in Johns Hopkins when a mother was brought in who was bleeding profusely, vaginally, and we knew, the doctors there, and I went into surgery with them, that they had to do some surgery. And they knew that in doing the surgery they were going to have to give her blood. They couldn't give her blood because before she went into surgery, she said, "I'm a Jehovah's Witness, I will not take blood, I will not take blood." Well, they couldn't get a hold of their lawyer, and they asked me, and I said, if you want a legal answer, I'll tell you that you can't give her blood because you would be assaulting her. You'll have headlines tomorrow morning. Her gratitude, if she recovers after you gave her blood, will be represented in these headlines that say, Johns Hopkins guilty of assault and battery, guilty of experiment. So I said, legally, that's the answer. And the doctor said, well, that's the answer that we have to give too. She didn't get blood, and she didn't make it. And I think that if it were I, not a lawyer, in a small community, I think that I would probably do otherwise. As a doctor, as a surgeon, but as a lawyer, I've got to do what the United States Supreme Court does when the prayer case comes up. I know Earl Warren is a God-fearing religious man, and I know that his personal sentiments and sympathies are different, but he can't have the luxury of having these personal sentiments and sympathies as a judge passing on something like this. In the future, what is the trend? I think they're going to keep that court modern. It's not going to be a runaway court. I think that it's the one great institution of objectivity in the United States. Well, we better get you back to work so that you can go about your course of Chinese paper hanging and all become trial lawyers.
I'd like to thank Mr. Belli on behalf of the student body for spending his very precious time with us. Thank you.